Hi, Avi Blumenstiel here with the Law Office of Vecchio Blumenstiel PLLC in Plano, Texas. This is the second video we're doing on a series of frequently asked questions about probates, wills, trusts, and estates here in the state of Texas. The question we're going to talk about today is another one that comes up frequently, and it's, do I need to probate this will? We get calls all the time from people who unfortunately have lost loved ones or parents, and they find a will among their personal effects, and they call us and say, hey, they left a will, do we need to probate it? Well, the default answer is yes, all wills need to be probated. And the reason that's the default answer is because of the nature of a will. As I mentioned in a prior video, there's a common misconception that people write wills and they're lists of wishes and instructions for your family. You're leaving a list for your family to say, when I die, I want the family to do X, Y, Z. That's not what a will is. Nobody writes a will for their family. A will is a list of instructions that's written for the court and the government. Why? Because there are pre-existing laws that say what's supposed to happen with a person's property when they die. A will is a request to the court saying, hey, ignore the laws that are brought in the Texas Estates Code, Chapter 201, regarding what's supposed to happen to my property, and instead enforce this series of rules that I wrote. Enforce these rules as if it was the Texas state law. That's what a will is. So because a will is written for the court, and it's a request for the court to enforce your wishes as law, then the will has to be admitted to probate, because probate is the process of proving the validity of the will, admitting it, and enforcing it. Until that happens, a will has the same legal validity as a napkin or a blank piece of paper, which is none. A will has no legal validity until it is probated. There's also a statute of limitations, a period during which you have to probate the will and past which you can't. And that's 4 years in the state of Texas. So if a person passes away, then you have 4 years to probate the will. And then after that, the will is no longer valid and the will will no longer control how the person's property is distributed or who gets it. There are a few exceptions to this, and there are a few situations where after 4 years it is possible to probate a will, but it's not a guaranteed outcome in those cases. Now, that's the default answer. There are some situations where a person passes away, and either the property they own at the time of their death, and when I say property here, I mean whatever they owned, be it their clothing, money, cars, electronics, anything the person owned, where the property is minimal, or it was all personal property, small effects, and really the cost of probating the will isn't really necessary. The family has an agreement as to what to do with it. Or a person might make arrangements in their lifetime to give away the property that's covered in the will. So at the time that they die, they don't own anything that the will pertains to. In those situations, there's really not much of a point in probating the will. Now, if you have a loved one who's passed away, or you find a will, even if it's after 4 years, and you're concerned about whether or not there's a necessity to have it probated, please give us a call. We're happy to talk to you about it and give you our opinion and our view about whether or not there's a necessity for probate, and hopefully help you to find the right solution for your situation. Thanks, and have a great day. Bye-bye.